Kirk, thank you so much for being here today. For those people that might not be familiar with your background, you've definitely represented a very high profile case, especially in Maricopa County. Tell people a little bit about your history, your background.
Sure. Well, most people know me as the attorney, the lead counsel for Jodi Arias. But before that, I worked in the death penalty unit at the Public Defender's Office in Maricopa County for about 6 years, I guess. And then prior to that, I was a deputy public defender for several years, handling all kinds of serious cases. And that's ultimately how I became Jodi Arias's lead counsel, being assigned as a public defender and being uh, forced to keep it after leaving the public defender's office, going into private practice. So that is the background. I'm very familiar with Maricopa County and a lot of the parties involved here.
So you were assigned to Jodi Arias's case, and in the beginning, I would imagine it wasn't as high profile as it soon came to be once the trial started. Or was it? Was it always huge from the beginning?
No, it really wasn't in one sense, because you think about, we compare it, and we're talking about Miss Vallow's case today. Um, she comes into it with a great deal of publicity, right? There's already a prior trial. There's publicity on that was live streamed, the most part anyway. Um, so she's very well known. There's been a lot of specials, what have you. When Jodi Arias went to trial in Maricopa County, at least the first time before we did the retrial sentencing phase, Miss Arias had done one special, 148-hour special, and a couple other interviews, and those had been done years prior. So there's kind of a different ambiance to it, if you will, because Miss Vallow comes into this so high profile to begin with.
So, Kurt, you did have the high profile case of Jodi Arias. Lori Vallow Daybell is, of course, high profile there in Maricopa County. What type of things do you think the defense is doing now to prepare as opening statements begin Monday and the trial starts?
Well, that would be an easy question to answer if she was represented by a counsel, right? Now that Miss Vallow has decided to represent herself, it's hard to say, because you have to really question what is her motivation for representing herself. And we can talk about some of those possible motivations if you want, Nate.
Yeah, what would there be? I mean, other than maybe she thinks she knows more than her attorneys, or why go pro se when you have experts who can help you?
Right. And I should preface every answer I'm going to give today, because we talk about Ms. Vallow and her mental faculties. She's obviously not a free thinking individual. So we're, in some sense, we're imposing logic upon an illogical mind. But one of the things I would say, Nate, is that one of the biggest reasons why a defendant will say, "Hey, I want to represent myself," is because they don't believe their public defender is going to work for them. They're not real attorneys. She might have heard things of this in the jail, so therefore she wants to represent herself. Another common reason that might be more applicable to Ms. Vallow, because we haven't heard her voice anything like that, might be this idea that the attorneys don't believe in their innocence. Therefore, they feel like their passion for their case, their belief in their innocence, will be more impactful on a jury than an attorney who is going through the motions, if you will. The third thing that I think can be interesting, that we haven't heard out of Ms. Vallow, but it's certainly part of her mental illness or ideations, is her religious beliefs. And sometimes a defendant will say, "Hey, I want an attorney that aligns with my religious beliefs, because I don't trust anybody who doesn't." So, that could play into it. I mean, who knows? Maybe she believes that, and I don't mean to sound flip here, but who knows? Maybe she believes her attorney is a dark spirit, or is low on her scoreboard or something of that nature, and she doesn't want that person leading her case. So there's a lot of things that could come into play there, but I think those are really probably the primary reasons.
What do you do as the attorney there, who's her advisory counsel, when you know that what the defendant is doing might not be the best course of action? Do you just have to kind of support it is and let it play out?
Yeah, ultimately you do. I mean, because you don't want the biggest sin, if you will. Well, there's no specific guidelines of what advisory council does. There's no like set of rules. But the biggest thing you don't want to do as advisory council is interfere with your client's right to represent themselves. So to be saying, don't do this, don't do that, what have you, or precluding them from trying to, argue against it is not a good thing. So a lot of attorneys will take the approach that they might try to steer the client or help them with certain motions or what have you. But I always think the cleanest approach, because you don't want to interfere with her right to counsel, is just if they call, you're in the office, you pick up the phone, you say your piece, and that's it. So that's probably what we're seeing out of this attorney here, because we're seeing Miss Vallow, Miss Daybell plow ahead, especially when we talk about this issues with continuances and her witnesses and everything that's being precluded, plow ahead against all reason to the contrary, which her attorney would probably be advising her of if she's even asking. I mean, she doesn't even need to ask, her counsel. She may just be doing all of this on her own, so to speak.
How much more difficult or easier does it make for the prosecution and the judge when you have a pro se defendant in such a high profile case?
Well, ultimately, it makes the conviction easier. I don't know that the high profile nature of it really alters that. It may, in the sense that it makes getting the conviction easier, but the road there may be more difficult by having a pro se defendant and or the high profile nature of it, because we saw and we know that juries, what things can kind of go one or two ways with a pro per defendant. One, it can take a lot longer because they're objecting, they're asking irrelevant questions, they're doing things that the jury, they need to be excused, the jury needs to be excused because they're going off in a silly direction, or they don't really say a lot. And maybe that's, you might have watched bulk of jury selection. I'm guessing Lori didn't say a lot. I'm guessing that the judge directed the voir dire enough to ensure her rights to a fair trial. The county attorney as well, Miss Kay, she's very experienced as a county attorney. So, all those things, if Miss Vallow, and if she doesn't have a defense to present, I mean, we hear her now saying, I can't call these witnesses, what have you. She's not going to have much of a case on her side, and cross-examination might be very minimal as well.
Now, one thing that's different in Maricopa County, or maybe the state of Arizona, you tell me, versus Idaho, is the jurors can ask questions of the witnesses.
Yes, that is a statewide issue. So if Ms. Vallow decides to take the stand, and I believe she's indicated that she is interested in taking the stand and having her advisory council read the questions that she has prepared verbatim, she will subject herself to the questions of the jury. Now, if they're plentiful, that could certainly take a long time. When we talk about that road to get to a conviction, that could certainly take a long time.
And so how does that work, Kirk? Do they, is it for every witness or just the defendant?
Every witness.
So at the end of this, let's say it's a state witness, the state questions, defense cross-examines, state, do they do re-examination and then
redirect? Yes.
Redirect, and then the jurors pass in note cards or something like that?
Yeah, the judge will typically give them a pad of paper or whatever they have, and they say, does anyone have any questions for this witness? If there is a question, that question will be passed up to the judge, and that judge takes a look at the question to see if it's legally permissible. Like, it can't call for hearsay, it can't be argumentative, something of that nature, right? And both parties will be typically, now how it might be done a little bit differently with Ms. Vallow being pro per, but typically the attorneys go to the bench and they discuss the legal viability of the question. If it's Ms. Vallow, she's on the witness stand, that won't be as much of an issue, but logistically, but then they go over the legal viability of the question. If they're considered legally viable, those questions are asked, and then each party has the opportunity to follow up on the answer. So if jurors, ask a particular question, the witness gives the answer. Both parties have a chance to follow up on that specific answer with their own questioning.
Let's say that there is a guilty verdict that comes down, Kirk. How soon will sentencing happen?
Well, given that we have typically, Nate, the parameters would be about 30 days. But given that we have two trials, it's possible and quite probable that the sentencing will be delayed until both trials are done. Because obviously, as we know, Ms. Vallow is not going anywhere. There's no real urgency to get her sentencing done. So I think it would probably happen after the incident related to Mr. Boudreau is litigated.
And is that something that the judge imposes rather than the jury?
The sentencing,
Sentencing, right?
yes.
Yeah.
The jury doesn't give recommendations or anything of that nature. There are statutory guidelines. The judge will have a range of sentencing options. I believe it's 25 to life. Is that correct? Yeah. And then the judge can decide whether that is consecutive or concurrent, and to whatever sentence she receives in the attempted murder case.
Well, is there anything that you're kind of keeping an eye out for as this trial begins next week?
Yeah, I mean, I think opening statements are going to be huge because I think we all don't really have a sense, because it's been so chaotic, where Miss Vallow is going with her defense, right? I mean, there's some pretty clear paths, and you asked me earlier, how long will this case take? Is it more complicated? What have you? This case, from a defense perspective, if I were her attorney, it would be pretty quick, because what I would be saying is they made the right conclusion the first time, meaning that Mr. Cox acted in self-defense, and they're trying to rewrite history. And that doesn't take a lot of cross-examination. It doesn't take a lot of putting forward evidence. I mean, I probably wouldn't even consider putting forward evidence. I would just try to rely on the history of those police officers. What Ms. Vallow will do, we'll start to get a sense of that in opening statement, to see where it goes, what's she going to put forward. And that will give us a key of how long this is going to take. Because I think, to emphasize what I said earlier, Miss Vallow is going to wind up convicted. It's just the process of getting there. How tedious is that going to be for everyone involved? But, the judge has shown an excellent patient disposition from everything I've seen. And as I said earlier, Miss K is very experienced, and, she doesn't have to do anything outrageous, what have you, to gain a conviction. She's going to have to differentiate the outcome or the conclusion that she wants the jury to reach now than from the conclusion that the Chandler Police and or the Maricopa County Attorney's Office reached when they did not charge Miss Vallow in any of this, or Mr. Cox in any of this.
Yeah, before he died, right?
Yeah, because that's really the ground in which you're fighting this case, because you're saying, and it's kind of funny because Miss Vallow, she wants the county attorney's office so bad. If she looked at their prior engagement and their prior disinclination to try the case or to bring the case against Mr. Cox, there could be witnesses within the county attorney's office that could speak to that she's not seeking out.
Right, that she could call as her own witnesses to try to go after the prosecution.
Potentially so. I mean, the intricacies of the case and getting a prosecutor removed is very difficult, but that would certainly be an avenue that I would, and I'm guessing that her advisory council and or her prior counsel did just that, and maybe came to the conclusion that they couldn't do that. So I don't want what I'm saying to be seen as a criticism of them, because that's a very complicated issue, but certainly one I think counsel would be exploring.
Yeah. All right, Kirk, anything that you want to add?
No, I hope, I guess, and one of the things that I think happens, Nate, is that you asked me, about the high profile nature and everything else. I just want to reiterate, when I think about these high profile cases, I mean, we're in the mix of Karen Reed right now, and Miss Vallow, Miss Daybell. I hope people don't lose sight of the victims in this case, because a lot of times when that happens, when we talk about the Karen Reed case and everything that's going on, I'll be talking to Vinnie Politan about that tonight. John O'Keefe's name never comes up, right? And in this case, I think Tylee and Ryan certainly got their due in the other case, and obviously they're not the victims in this case. But I think we hear, so she's called the doomsday mom, what have you. We hear so little about Charles, and I hope his memory and his legacy sight isn't lost on that when we talk about all the craziness that might ensue over the next few weeks before Miss Vallow
Right.
is convicted.
Very
So
good.
that's the only thing I would say in that regard. And I appreciate people like you who make sure that doesn't happen.